Detention Center versus Minister of Justice and others.
May it please the court, I appear for the applicant.
May it please the court, myself together with my learned colleague, Ms. Ellis, who appear for all the respondents.
Thank you, Ms. Guzman. Thank you, Ms. Nkari. Just before you say anything, just to confirm my decision communicated to both of you yesterday, that as JP of this division, in consultation with my Deputy Judge President, we took the decision to put together a full court to hear this matter. And what you see in front of you is that full court, right? Just to confirm that part. The second aspect that we needed to deal with before we hear any argument is to check whether the order issued yesterday by Justice Fabricius has been complied with or not, because that determines our jurisdiction in this matter.
If I could answer to begin with, I can only answer as to the third paragraph relating to the further conduct of proceedings. From our point of view, the answering affidavit, I understand, was collected by my attorneys from the respondents at 10 to 11, which was when it was ready, and I've only received it at 11:15. We therefore haven't yet filed a reply, but I don't think that we intend to do so.
I just need to hear the issue I've just raised now.
Beyond that, I can't confirm. We're also not aware ourselves whether President al-Bashir is still in the country, and we'd seek a clarification from the respondents in that regard.
Advocate Nkari?
Insofar as the court order that was granted, the interim order that was granted yesterday by Justice Fabricius, I'm told that it has been complied with, especially insofar as paragraph 2 of that order is concerned, which required the Director General of the Department of Home Affairs to effect service of the order on the officials in charge of each point of entry in the Republic. He has done so, but insofar as he has experienced difficulties, then I will put them on record, because paragraph 2.2 required him to also provide proof of such service. So indeed, I have with me here this bundle. Unfortunately, then we do not have the copies, but we'll make the copies available, which show the transmission of the information by the Director General or his delegatee to the ports of entry. And I'm told that by the time when I was given these documents, there were only 5 ports of entries for which he has not yet received confirmation from. But from all others, then he has received confirmation, which I have. Insofar as the order which required that President Omar al-Bashir should not leave the Republic, I'm aware of the reports which appeared in Bloomberg that he had left the country, but those reports were as surprising to us as government as to anybody else. So there is no confirmation of his departure. So as far as we are concerned as the government, then this court still has jurisdiction to deal with the matter.
Are you saying, Advocate Nkari, President al-Bashir is still in the country?
To the best of our knowledge as the government, then he is in the country. Okay. If there's anything to the contrary, we'll immediately bring it to the attention of the court.
Okay. Thank you very much.
As a court, please.
Now, the next housekeeping issue that we need to deal with is we received the respondents answering representations as we were preparing to come to court. So we have not had sight of or perused and considered what the respondents are saying. I just need to clarify, because as a court, we would like some time, not a lot of time, just to have a sense of what the respondents are saying, and to also determine whether the applicant wishes to file a reply.
Yes, indeed, my lord, we are of the view that this is an extremely important matter, and we appreciate the fact that yourself, in your capacity as the judge president, has taken the lead by ensuring that it is heard by the full bench, and would like the full bench to have or to be in a better position to adjudicate this matter because of its significance. So I made submission to Justice Fabricius yesterday when we sought a stand down of this matter to today, 11:30, that my instruction is that President Bashir has been invited to attend an AU summit, which finishes today, this evening. So that if indeed President Bashir has come to attend the AU summit, I saw no risk whatsoever of President Bashir disappearing before he executes the business of his government, which he has come here for. So I will submit myself that it is 11:45 now. If the matter can stand down to 2 o'clock, then this court will be in a better position to deal with the matter, having regard to the affidavit that has been filed by the state respondents, taking into account that although the affidavits are relatively short, the main affidavit is 24 pages, and the supporting affidavit by Dr. Lubisi, the Secretary of Cabinet, is also 5 pages, but the annexures are relatively voluminous. And we submit that it will be significant for the court to consider those annexures, because we're going to make submissions in relation to those annexures, which in our view are legal instruments which ought to be taken into account. So if then the matter stand down to 2 o'clock, it will afford the bench an opportunity to peruse this answering affidavit and to be able to be in a position to deal with the matter appropriately. So those will be my submissions.
Look, I'm not sure we need that much, but I'll talk to my brothers.
Indeed.
Let me hear what the applicant's view is on
My
this.
Lord, if I might weigh in very briefly. I've had an opportunity only to read the main affidavit filed by the Minister of Justice. I haven't read the supporting affidavit by, I think, the Minister of International Relations, but it appears to me brief. The affidavit we submit deals largely with legal argument. There's very little factual material in it, and so the vast majority of the case is common cause. We do not intend to put up a replying affidavit, and so the papers will end with this affidavit. I don't wish to hurry the bench into reading something or to rushing through papers and putting you under undue pressure. And we're indebted, like my learned friend, we're indebted to you for convening the court. But for as long as there are ports of entry that haven't yet confirmed that they will hold President Bashir in the country, and for as long as we don't know which those ports of entries are, and in particular whether or not they include Waterkloof, which where reports have said that the Sudanese plane is getting ready, has been seen landing. We say that the matter remains urgent and that there remains a very real risk that President Bashir will leave and that this application will be rendered moot. So we would urge the court, to the extent possible, to hear this matter expeditiously and, if possible, before 2 o'clock. But we are in your hands as to timing.
The other thing I want to deal with is the flash photography. I want to issue an order that we don't want it. We have to use flash photography.
Yes,
I don't want
that's
it.
very
Yeah. as well as movement around. But the issue of the remaining ports of entry that have not confirmed, what do we do? Should we say Advocate Mkari when we reconvene in Australia?
I think so. You know, the number, like, you can depart from through Botswana, Swaziland, you know, various little points to Mozambique.
We are going to adjourn for an hour to go through the answering representations that have been filed. And then we're going to come back in an hour's time. That's the one thing. The other thing is, Advocate Mkari, when we reconvene, we would like you, through your attorneys, or your attorneys through you, to inform us of those ports of entry that have not been responsive.
We'll just,
Because jurisdiction is important to us.
indeed, we'll just,
The Implementation Act is clear in that regard. So that's the second thing. The third thing is, we are agreed and we're issuing an order that during the proceedings here, there shall be no flash photography. I've seen some flash photography since now. There shall be no flash photography and there shall be no moving around in the courtroom during the proceedings. Is that clear?
as a court.
Thank you. The court shall adjourn for an
I know,
hour.
sorry, I beg your pardon, Chair. We have prepared a bundle of authorities with the relevant legislation, and I've also prepared brief heads of argument. Would it be convenient to provide them to your lordships now?
That's fine. That's fine. Advocate Mkari, have you done the same?
No, but we did receive the bundle of authorities from our land affairs.
Sorry.
Thank you very much. Court adjourns for an hour.
theoretically possible that none of the respondents here would know, for instance, whether the plane had taken off from Waterkloof Airport? How would that be possible?
I've not said they don't know. If your Lordship allowed me to finish, what I'm saying is that we have received media reports whilst we're in court that Bashir has left. I'm saying these are the same reports which were made yesterday which were not correct. Because upon our verification yesterday, we realized that the reports were false. So now we have the same reports which are made now, and all I'm saying to them to the court is the following. I have requested the Director General of the Department of Home Affairs to verify whether these reports are correct. In fact, then they are very specific that the plane left from Waterkloof. So in order for us then to confirm to the court that indeed the reports are correct, we should be able to provide the planes which have left Waterkloof from yesterday until now. So that is what will be able to confirm that indeed then he has left. So the Director General said to me, he will come back to me. It is just that by the time when the court convened, he had not been able then to come back to me. But we are very specific that we should be able to give the court accurate information and not media reports.
Thank you, Advocate Mkhari.
Thank you.
So as we sit, you are of the position that President al-Bashir is still in the country.
As we sit, I do not have the official confirmation that he has left the country. I only have media reports that he has left the country. But also the media is saying that they saw a Sudanese airplane taking off. But that cannot on its own be conclusive proof that President Bashir has left, because we do not know whether, even if it has left or it has taken off that plane, where it is going to, and secondly, whether he is in that plane. That is why I require a formal confirmation from the relevant authority, and that will be the Director General, because at the port of entry, then when one then checks in, there should be then documentation which will be able to show that who actually then moved in and who took off. So that is the relevant documentation which will actually tell us whether indeed he is in the country or not. Yes, that's why I said that at the time when the court convened, I was waiting for the DG then to come back to me. So if then, the matter is 5-1, if the matter can stand down for 30 minutes, then I'm sure by that time we should be able to produce then the relevant documentation which will show that in fact then he is still in the country. But what I must also point out is the following.
I don't want you to belabor this, because we've got a matter that we need to consider and decide upon.
Indeed.
So whatever we're hearing is speculative.
Indeed.
All of you sitting here don't know what the situation is. So that's why I asked you the direct question. As we sit, he is still in the country, unless you hear something to the contrary afterwards. I suspect the people behind you want to give you instructions.
Oh, maybe they have breaking news. The official will be verifying the information that I was submitting to court that we would like to put before court. But what he was saying to me is that he understands his name is not in the list of the people who have taken off from OR Tambo and from Waterkloof, but he wants to then get the exact verification. So Your Lordship is correct that as we speak, there is no official confirmation that President Bashir has left. Until that confirmation comes, I can certainly assure the court that I'll bring it to the attention of the court.
Yeah, I think we need to leave it there for the moment.
Indeed, my lord.
But it is important to us.
Yes, indeed.
I've read the Implementation Act very carefully.
Yes.
If he's not in the country,
The court doesn't have jurisdiction.
we
Yes.
have no jurisdiction.
Indeed.
That's why we want to deal with this.
Indeed.
Whatever information comes to hand.
Yes.
So the other issue that you may want to get instructions on is the AU is currently happening.
The AU is still in session.
It's still in session.
It's still in session.
So it's easy to verify whether he's there in conjunction with the other report, whether he's also taken up, isn't it?
Not necessarily, because then yesterday, apparently what happened is that when he could not be seen on the seat that he occupied, it was concluded that he had left, when in fact he could have just taken, a break.
Yeah.
So we cannot really then say that if they don't see him
Yes.
at the AU he has left, he could be in the hotel room or he could be doing shopping or doing other things. So we cannot really rely on that indeed.
Okay, let's leave the matter there. And then, is there anything else you want to say? Shall we start?
No, what I would like to say is that should any information come to my attention about or information which will impact on the jurisdiction of this court, I'll certainly bring it to the attention of the court. As a court.
Thank you, Advocate Mukari. Ms. Goodman?
If I could again trouble the bench for one more request. During the recess, I asked my learned friend specifically for confirmation that Waterkloof is on the list of ports of entry that they have confirmed. And I repeat the request through the court. There seems to be some ambiguity on the Home Affairs' website about whether or not it does qualify, and we'd like some clarity on that issue.
Yes.
Ms. Goodman, I heard Advocate Mukari say the 3 remaining are remote, and he didn't mention Waterkloof.
The issue, as I understand it, my lord, is that as we understand it, in order to leave from Waterkloof, President Bashir would have to be stamped out or allowed to leave by an official from the Department of Home Affairs. But it's not clear that if he leaves from Waterkloof that it will then become a port of entry or exit within the meaning of Home Affairs as ambit, because it ordinarily operates as a military base. So we just seek a factual confirmation one way or the other, whether the list of confirmations that they have includes Waterkloof or excludes it.
No, I agree that actually, then my learned friend did ask me that question. In fact, it escaped my mind when I was putting other matters before court. I promised that I will verify that. I did verify that. What I was informed is the following. Whilst Waterkloof does not operate as a normal port of entry, it does not have immigration officials who are stationed there full-time. It will only receive an immigration official only when there is a plane which is to land or a plane which is to take off. But I've been assured that despite that, Waterkloof was also notified, and the person in charge in the morning was informed about the interim court order. As a copy.
Thank you, Advocate Mukari. Thank you. Advocate Goodman? Look, we've read the papers. We don't expect argument to be lengthy because we think it's legal argument. So I'm just saying that to both counsel, that it's mostly legal argument that we want to hear.
Bearing that in mind, I will be brief. Our starting point is that the Rome Statute has been domesticated into South African law through the enactment of the Implementation Act of the Rome Statute of the International Court. The effect of that Act under Section 231 sub 4 of the Constitution is that the provisions of the Rome Statute as well as the supplementary provisions contained in the Act themselves, become binding South African legislation. And that has been repeatedly affirmed both by this court and by the Constitutional Court. It's come up before this court twice, first in the torture docket case, which appeared before His Lordship Justice Fabricius, and also in the case concerning the attempt to arrest and surrender the former president of Madagascar, Mr. Ravalomanana. My learned friend, the respondent's answering affidavit suggests that the torture case in the Constitutional Court is not necessarily decisive of the matter because it deals with the investigation and potential charge of crimes, international crimes in South Africa, as opposed to the arrest and surrender of someone to the International Court in The Hague. We do not accept that interpretation. We say that the clear wording and the findings in the Constitutional Court's judgment were to the effect that the Rome Statute is domestic law. And that is clear in particular from paragraphs 33 to 35 of that judgment. The relevant provisions, and I am mindful that we're under time pressure, so I don't intend to read them, but in those paragraphs, the court confirms specifically the importance of international human rights law and international humanitarian law in our constitutional regime. They relied in that regard on the Glenister judgment, and that you can find at paragraph 22 of the Concourt's judgment. Correct. That's right. So 22. Correct. And that obligation functions, we submit, at two levels. So it is both an international, well, three levels. It's an international obligation by virtue of South Africa having signed and ratified the treaty, and so that operates at the international level. It's a constitutional obligation by virtue of Section 231 sub 4, because 231 sub 4 says that when domestic legislation is enacted to ratify international obligations, that there is then a constitutional obligation, it then becomes law. Compliance with it becomes an element of the rule of law, and it's therefore a constitutional obligation to comply.
How can a government notice, which is, if you look at old administrative law phraseology, subservient even to a regulation, which is obviously subservient to an act of parliament, how can a government notice override or overrule an act of parliament which was created to abide by an international agreement?
I suspect, my Lord, it's a question you need to ask Madam Fred, because I will not.
Isn't that the crux of your case?
It is the crux of our case. I understand the respondent's case to be slightly different. So I think that rather than relying on the notice, they rely on two prior agreements which they say inform the notice. And they say on the one hand it's the agreement with the African Union Commission, which then adopts the Organization of African Unity's convention privileges. And there's a debate between us as to who gets those privileges under both the agreement and the notice. And then they rely on a second cabinet decision, which, as far as I can tell from the affidavit, is not given effect to. And that cabinet decision is to the effect that they will well, perhaps I should take the court to it. It is the last annexure to the answering affidavit put up this morning.
Is that the one in Mr. Lubisi's affidavit?
Correct, the supporting affidavit from Dr. Lubisi. And the relevant provisions, the relevant sections of it start from 3.1, where they say, 3.1, they say Cabinet was made aware of the fact that President Bashir was planning on coming to the summit at the beginning of June. They say that the confirmation of his attendance was accompanied by a request from the Republic of Sudan that President Bashir will be accorded all the privileges and immunities of a delegate attending the AU summit. They then say, and then they note that they make note about the charges against him, and then turning to 3.6, they say during early June 2015, Cabinet requested advice from his Chief State Law Advisor and deliberated on this issue at length. That's the issue of whether to grant the request. During said discussions, Cabinet was apprised of the host agreement with the AU, which is the agreement with the Commission, which I'll come back to, together with the intention of promulgating Article 7 of the host agreement, that's the section that gives the privileges, as well as the implications thereof on the immunities and the privileges enjoyed by President Bashir as a head of the member state of the AU. Cabinet collectively accepted and decided that the South African government as the hosting country is first and foremost obliged to uphold and protect the inviolability of President Bashir in accordance with the AU terms and conditions, and to consequently not arrest President Bashir in terms the ICC warrants whilst he's attending the AU summit. So the position as we understand from the papers, it's not terribly clear, but as I understand this affidavit, he says that they took a decision that that he was entitled to the protection of the notice that had been issued under the Diplomatic Immunities Act.
But does the government notice say that?
No, which is the point I'd like to come to. The government notice, both the agreement, the provision in the hosting agreement and the term in the government notice are identical, so the court can have regard to one or the other. But
Is this your point that that covers only commission members and
commission members
and staff members?
Commission members and staff members on the one hand, and representatives and delegates of intergovernmental organizations.
And you say it does not cover a head of state.
Correct.
Can you tell us why you say that?
I can. I think the best starting point for that is the reliance on the agreement itself. So if the court could go to Annexure A,
Yeah.
which is the agreement between the Republic and the Commission of the African Union. As the answering affidavit notes, I'm sorry. As the answering affidavit notes, the agreement is it's a facilitation agreement. It sets up various, for the most part it's concerned with the organizational terms on which the AU summit will be held and what South Africa's obligations as a hosting country are to make facilities available. So we'll see that well over half of the provisions of the agreement deal with that. But more and it's only then at Article 7 that the issue of privileges and immunities comes up. Now, significantly for the purposes of the agreement, the terms of the agreement are very careful to differentiate between, on the one hand, staff and members of the AU itself, and member states on the other, and participants in the conference in the summit who presumably attend on behalf of member states. And if I could just give a couple of examples of that. The first appears on page 6 under capital C. It's almost at the bottom of the page. You'll see there that it requires the government to make available at its own expense 3 sets of national flags of each member state. Up until then, sorry, if you page back up until then, the provisions all deal with meeting rooms, premises available, equipment and office supplies. So they're really just things, facilities. Over the page at D, telecommunication facilities have to be made available to the chairperson of the African Union, the chairperson and deputy chairperson of the Commission. The international communication facilities have to also be made available to them. So again, you see there and lower down the page reference to specific officials of the African Union.
Ms. Goodman, I think just deal with Article 8, because that's what we deal with.
Sorry?
Article 8.
If I could have a moment just to go there, I will be brief, but if I could take you to the top of 10, which deals with 4, and then I will move straight to it. Article 4.1 on page 10 deals with participants. And it's in clear contradistinction to all of the other provisions of the agreement which talk about staff members. Participants deals with people who attend the conference and they are entitled to medical facilities. Now, in that context, I go to Article 8, which is over the page. And on the words of that, it says, the government shall accord the members of the Commission and staff members, that's clearly members of the Commission and staff members of the Commission, there can be no other interpretation of that, and the delegates and other representatives of intergovernmental organizations attending the meeting, the privileges and immunities set forth in sections C and D of the Organization of African Union Convention. Our submission is that when that talks about delegates and other representatives, that can only mean delegates of intergovernmental organizations. Because if it meant delegates of state, the use of the word other would be nonsensical. The fact that other is used in that sentence is to differentiate representatives from intergovernmental organizations who are formally delegates and all other representatives on the other hand. Now, so on the plain text of this provision.
The phrase members of the commission.
Yes.
Who does it cover?
It covers officials of the commission, we say. So it would be...
Not member states?
No, not member states. And that's why I started with going through those earlier provisions. Where it talks of member states, it talks of member states or participants in the summit. And so we say members of the commission can only be their officials and appointees. Now, that we say is also clear from the provision in terms of which the agreement was given effect to. The court will be aware that under Section 7 of the Diplomatic Immunities Act, it is a requirement that any agreement giving effect to immunity is published in the Government Gazette. And we say that's a promulgation requirement. Until that promulgation happens in the Government Gazette, there can be no force and effect of the agreement. And that it seems to us that the state respondents agree with that because they use the word promulgate in their answering affidavit. They say the effect of the publication in the Gazette was to promulgate the notice and thereby to give it effect in domestic law. Sorry, I'm just finding the notice. If your lordships would then turn to the notice, it may be easier to find it at the back of our... I do apologise for not having paginated papers. But it may be easier to find it at the back of the supplementary affidavit. It's about 5 pages from the end. And it's KRK 15. A copy is also attached to the state respondent's answering affidavit. Theirs comes from the Government Gazette, ours comes from the Electronic Gazette. At the top of the page is the pronouncement that one would expect from the minister. It says, in accordance with the powers vested in me by Section 5, Sub 3 of the Diplomatic Immunities and Privileges Act. And the invocation of the power is significant, we say, because the different subsections of the Privileges and Immunity, the Diplomatic Immunities Act, deal with different kinds of personnel, different people that the minister can give powers to. And Section 5 of the Act deals with immunities and privileges of the United Nations, specialized agencies, and other international organizations. And the term organization is defined in the Act to mean an intergovernmental organization of which 2 or more states or governments are members, and which the minister has recognized for the purposes of this Act. So the African Union would qualify as an organization, but a member state would not, because it doesn't comprise of more than one member state. 5 sub 3 is the generalized provision. So sub 1 deals with immunities on the United Nations, sub 2 deals with specialized agencies of the United Nations, and then sub 3 is the catch-all, which says any organization recognized by the minister for the purposes of this section, and any official of such organization enjoys such privileges and immunities as may be provided for in any agreement entered into with such organization. In other words, 5.3 empowers the minister to confer privileges and immunities on the AU, and as she has purported to do. The provision that she invokes to explain the use of her power totally excludes any suggestion that she invoked the power also for the purposes of granting immunity to any member state or any head of state. And we say that is also clear. That is clear also from the structure of the Act, because immunities and privileges of heads of state, special envoys, and representatives, in other words, individuals from members of state, are dealt with under Section 4 of the Act. In other words, there are 2 mutually exclusive regimes. The minister could have invoked both. She could have invoked Section 4, but she didn't. She invoked exclusively Section 5.3. And we say that is consistent with the wording of the notice, which confers privileges and immunities only on intergovernmental organizations and members and staff of the AU itself.
So where do they get immunity then, coming here? Members of states, heads of states?
My Lord, the answer is twofold. The first is that the majority of heads of state will enjoy immunity by virtue of customary international law. And Section 4.1 of the Domestic Immunities Act gives effect to that. It says that the Act recognises that where customary international law applies and confers heads of state immunity on a person, that will apply and will exclude jurisdiction of the courts. The situation with President al-Bashir is different because he no longer enjoys head of state immunity under customary international law. And we say so because of the provisions of the Rome Statute itself. In other words, Article 27 of the Rome Statute provides that excludes head of state immunity. I'm just finding the provision, if you'll bear with me for a second. So it provides, sorry, it is in the bundle of authorities that we handed up to your lordships. But Article 27.1 says the statute shall apply equally to all persons without any distinction based on their capacity, in particular official capacity as head of state or government, a member of government or parliament, an elected representative or a government official shall in no case exempt a person from criminal responsibility under the statute, nor shall it, in its and of itself, constitute a ground for reduction of sentence. And then immunity or special procedure rules which may attach to the official capacity of the person shall not bar the court from exercising its jurisdiction over such person. Now for the answering affidavit criticises us for relying on this provision. They cite Section 4.1, which is in similar terms but applies where a prosecution takes place in South Africa domestically. And the respondents point out that the exclusion of immunity for the purposes of criminal responsibility is they say, a question of whether or not the crime attaches. But we submit that even if that was so, Sub 2 makes very clear that head of state immunity or any other immunity that would ordinarily apply does not exclude jurisdiction of the court. And consequently, when the Act is applied in South Africa, cannot exclude this court's jurisdiction. So, to sum up then, the ordinary position would be that President Bashir would enjoy head of state immunity under international law. That head of state immunity does not apply insofar as the provisions of the Rome Statute apply. In other words, there is an exclusion of immunity for the purposes of the Rome Statute. And it means that he cannot invoke head of state immunity to claim protection from the jurisdiction of this court.
Ms. Whitman, can I just ask you, with reference to your eNCA KRK 16?
Yes, my Lord.
If you can just find that.
Yes, I've got it in front of me.
In more or less, there is a document emanating from the Petard Chamber of the International Criminal Court dated 13 June. And on page 5 of that document at the bottom, if you can just have a look at that.
Yes, my Lord. That is exactly, it confirms exactly the point we see.
That's what I wanted to ask you, because it says that the Security Council of the United Nations, by resolution that is mentioned here of 2005, revoked the immunity. Am I reading this correctly or not?
Yes, you are. Your Lordship is reading it correctly.
And is that why you said that in terms of Section 4 of the Immunities Act, the President does not enjoy customary immunity?
My Lord, I need to double check what that security resolution is. I don't want to make submissions.
No, you know why I'm asking you, because you don't deal with that topic in your heads of argument.
It's not that.
I accept the point. I will need to check the wording of that Security Council resolution. Our submission primarily those that the...
Resolution 1593 of 2005.
I will take instructions on it.
Well, I found it strange that you referred to it, but you don't deal with it in your case. because it would be one of the bases you would rely upon to say his immunity is gone.
My Lord, we do refer to this judgment in the heads, and we say that
To this resolution.
Oh, sorry, not to the resolution. The resolution is not referred to in our papers, and so I couldn't put it up in the heads, but I will check the wording of that before. I prefer to check the wording of that before I make submissions on it. For present purposes, we say that the ICC itself has confirmed that at the international level, President Bashir enjoys no immunity, and their pronouncements in that regard are definitive for international law purposes. We say also that must follow as a matter of law from the provisions of the Rome Statute itself. It may be that the Security Council resolution strengthens our position in that regard, but I will need to check the wording of it before making instructions.
The mere fact that 2 warrants of arrest were issued by the International Criminal Court, doesn't that imply as a matter of necessity that there is no immunity?
My Lord, I think it would beg the question. I think that it's not clear to me that they could issue the warrant if there was immunity. It's by virtue of the fact that he doesn't enjoy immunity whilst he's sitting as a head of state that they issue the warrant. But your Lordship is correct that the fact of the warrants is conclusive proof that he doesn't enjoy immunity from prosecution at the ICC level. And insofar as the ICC obligations are duplicated at the domestic level by the domestication of the ICC of the Rome Statute, submit that the same principles bind this court.
You also make representation, so the argument that the Organization of African Unity Privileges and Immunities resolution has not been or was not domesticated in the country. To what extent does that take your argument further?
My Lord, the position would be this: if the OAU Convention on Privileges had been domestically enacted, then it, like the Rome Statute, would enjoy domestic force of law. Its provisions would then be binding upon the judiciary in South Africa. The fact that it has not been means that it doesn't enjoy that status. It means that for domestic law purposes, the provisions of the ICC Act under the Rome Statute must trump those provisions. And indeed, we would go one step further and we would say that under Section 231 of the Constitution, which requires that an international treaty must be domesticated before it takes effect unless it is self-executing. In terms of we'd say that in terms of Section 231, the Convention is not enforced in South Africa and cannot constitutionally be enforced as though it is domestic legislation. The distinction between self-executing legislation is dealt with in the second Glenister judgment, but for ease of reference, the distinction it relates mostly to procedural type conventions rather than conventions that deal with substantive obligations that the member state has to take an affirmative decision to adopt. So we say that the convention is clearly not a self-executing document. It hasn't been enacted domestically, and it's therefore not binding domestically.
One further question from myself. The state party status of South Africa in the Rome Statute, coupled with the Implementation Act in the country, viewed with the notice issued by the Minister of International Relations and the cabinet decision, you say the latter two do not have the effect of excusing South Africa from its obligations as a state party to the Rome Statute to effect the arrest.
Yes. And if I could just deal with the last two separately. I've made submissions to your lordships that the notice does not purport to grant immunity to heads of states. And so our primary argument is that it simply doesn't apply. It doesn't confer any privileges and immunities on President Bashir at all, and nor to any other heads of state. If we are wrong on that, then we fall back on the submission that the most that the Minister of International Relations can do under the various provisions of the Diplomatic Immunities Act is to exercise a discretion to grant immunity and privileges on a case-by-case basis. It is a principle of the rule of law that she must exercise that discretion in a manner that is lawful and consistent with her constitutional obligations. And so we would submit that if the effect of her exercising that discretion would be to confer immunity on President Bashir in breach of the Rome Statute and therefore to allow South Africa as a state to circumvent its obligations, then that would be an unlawful exercise of discretion. It would be ultra vires her powers. And
it's not your case that this has happened. It's not the defendant's case.
I think that their case is, my lord, that the notice confers immunity on him.
On him specifically.
As I understand their case, they say the notice plus the cabinet decision together mean that he enjoys immunity. Now, to deal with a brief technicality, the respondents take a technical complaint
Just
that...
before you go to the technicality, so do I understand your argument in simple terms to be for South Africa not to regard itself bound to effect the arrest, they must get out of the Rome Statute? Get out of the Rome Statute.
Correct, my lord. We submit that the primary starting point is that the Rome Statute is binding, an arrest warrant has been issued, a call for cooperation in arrest and surrender has been issued, among others, to South Africa, and there is therefore a binding obligation on South Africa to arrest and surrender President Bashir. That is a legal obligation. It cannot be trumped or circumvented by a notice exercised on a discretionary basis by the minister, because when she exercises the discretion to circumvent that obligation, she acts unlawfully.
You're dealing with a technical argument now.
Yes, my lord, I'm returning there. The respondents take a complaint that we don't attack the validity of the notice in our notice of motion. It's correct, we didn't do so because at the time that the papers were prepared and served, we hadn't yet seen the notice. But the supplementary affidavit, which was served on the respondents yesterday morning, expressly records our intention in the alternative to move to have the notice declared unlawful and invalid to the extent that it purports to confer immunity on President Bashir. That appears at paragraph 9 of the supplementary affidavit. And we submit that relief, the respondents have therefore been put on adequate notice that we intend to seek that relief. And it falls within the further and alternative relief heading that we could seek in terms of the notice of motion. To the extent necessary, we also seek such condemnation as we might need to amend urgently now. But our primary position is that it's not necessary to do so. They were aware that was the case they were called to meet. If I could then very briefly deal with the cabinet decision. As I read the affidavit, the cabinet decision pulls itself up by the bootstraps. It says, Cabinet decided to confer on President Bashir those privileges and immunities that were already conferred under the notice. If our primary argument is correct that there are no privileges and immunities conferred on him under the notice, then the effect is that there are still no privileges and immunities conferred on them. In other words, their extension is a mistaken extension and has no effect in law. But even if that was not the case, the cabinet decision of itself has no force in law. And that is because of the provisions of the Diplomatic Immunities Act. To return to the Section 4 of the Diplomatic Immunities Act, it provides that head of state immunity can be granted in 3 different circumstances. The first I've already canvassed is when it is conferred by customary international law, and I won't repeat that. The second is where it's provided for in an agreement entered into with the state or government, where such privileges and immunities are conferred upon a head of state. And the third is where it's conferred on a head of state by virtue of Section 7.2. And Section 7.2 provides the minister may, in any particular case, if it is not expedient to enter into an agreement, she may confer privileges and immunities on an ad hoc basis. Now, the cabinet decision falls into none of those three categories. It's not customary international law. It's not an agreement because there is no suggestion on the papers that there was a formal agreement concluded between Sudan and South Africa pursuant to the cabinet decision. And nor is any agreement attached. There's a further problem with that, which is that under Section 7.2 of the notice, such agreement would have to be published in the Government Gazette and promulgated to take effect in South African law. So it doesn't fall into that second category of immunities allowed for under Section 4.2 of the Immunities Act. And nor does it constitute an ad hoc decision because the decision is not taken by the Minister of International Relations, who is the only official empowered to consider and take the decision under the Immunities Act. And again, because even if she had taken that decision, she would have to promulgate it in the Government Gazette to give domestic effect to it. So we submit that the cabinet decision, such as it is, and what is before your lordships is very bare, has no effect in law. It cannot confirm privileges and immunities because that is not what it purports to do. It has no legal effect, and even if it did, it would suffer the same defect that the notice would if it applies to President Bashir, namely that it would nevertheless be the conferral of immunity on a discretionary basis in circumstances where that puts South Africa as a state in breach of its obligations to arrest and surrender President Bashir. In other words, it would be a discretionary attempt to circumvent a mandatory obligation in law. So we submit in those circumstances that there is no basis put up. There is no adequate basis put up, or no cognizable basis put up by the respondents for conferring immunity on President Bashir. And in those circumstances, he is subject to the jurisdiction of this court. Submit further that the state respondents are clearly in breach of their obligations to give effect to the procedures that lead to the arrest and ultimate surrender of President Bashir. And we submit that must be the appropriate remedy in the circumstances of that case would be to remedy that firstly by a declarator of South Africa's obligations in order to remove any uncertainty as to whether or not there is immunity or any other basis for refusing an arrest or surrender, and then to trigger the arrest processes in the ICC Implementation Act. In our papers, we sought one of two routes to do so. We sought either an arrest without warrant in terms of Section 40 of the Criminal Procedure Act in order to procure President Bashir remaining in the country. Or we said in the alternative that provisional warrant could be issued in terms of Section 10 of the ICC Act, which is the usual process. So in terms of the Act, when someone is in South Africa and a warrant exists for their arrest from the ICC, they are provisionally arrested under Section 10. They are then taken before a magistrate in order to ensure that they are the right person, to afford the person arrested an opportunity for outing, and they are then surrendered to the ICC to be taken to stand trial.
And is therefore intended to be the alternative to prayer free?
I'm sorry, my lord, if you give me a minute just to find it. Correct. So when we brought the application, we understood that we anticipated that the most expeditious way of securing his arrest would be in terms of the Criminal Procedure Act without warrant. We submit that provided the existing interdict on the state respondents precluding them from allowing President Bashir to leave the country remain, then it is as well to invoke the ordinary procedures under Section 10 of the Implementation Act.
I mean, then also, is prayer too important to you, to your case?
My lord, we'd submit that it is important to our case in the way that all constitutional declaratory relief is. In other words, it serves to give public clarity on the extent of the state's obligations.
Doesn't the Constitution say that the court must declare such conduct unlawful?
Your Lordship is of course right. In terms of Section 172 of the unconstitutional conduct must be declared invalid, and then 3 or 4 would be the consequential relief. And 5, we submit, must remain in effect in order to ensure that President Bashir does not leave the country in the interim. I'm sorry, if I could raise the issue before I address your Lordships on costs. The state respondents do take an issue with urgency. But as I understand the objection, they say, because there is no obligation to arrest, it appears in paragraph 33 of the answering affidavit. They say, I deny that this matter is by its nature urgent. It's clear that President Bashir will attend the AU summit under the auspices of the specific terms and conditions of the AU. More specifically, the privileges and immunities accorded to him as an invitee of the AU. Accordingly, there's no room for the allegation that he should be arrested. We say that doesn't go to urgency, it goes to merits. They say if he in fact is under a privilege and immunity, and therefore he can't be arrested, and so the entire application is an exercise in futility. But we submit that the earlier question is whether or not there was an urgent need to bring these proceedings urgently before this court, and we say the urgency of the matter is manifest from the fact both that President Bashir is here for a very short period, and that there are indications that he may well intend to leave before any order can be granted by this court. So we submit that urgency isn't an issue. Turning then to costs. The applicant, the Southern African Litigation Centre, in its affidavit sought the costs of 2 counsel. That is an error. I am alone. Sorry? Oh, that's true. We all act pro bono. And so the costs would be those recoverable to the extent allowed in pro bono litigation. We submit that if our application fails, that the applicant should be protected against an adverse costs order under the ordinary Biowatch rules. This is plainly a constitutional issue. It's brought in the public interest, and we submit that it is plainly not frivolous or vexatious. And unless your Lordships have any further questions, those are our opening submissions.
Thank you very much. Have you received any further instructions?
Just a moment. I'm told that his name is still on the list of the people who have departed from Waterkloof. It's not on the list. My Lord, can we start by looking at the applicant's heads of arguments? If we can go to paragraph 15 of the applicant's heads of arguments, so that we can properly understand what precisely is the applicant's case. In paragraph 15, the applicant says the following: the only grounds on which President Bashir could conceivably be alleged to enjoy immunity would be as a head of state or in terms of the June agreement. But in fact, neither basis confers immunity on him. And when we turn to paragraph 16, the applicant submits that the June agreement does not confer immunity on heads of state for reasons I return to below. President Bashir could thus only claim head of state immunity based on customary international law. So that is to the extent to which we understand the applicant's case, that they appreciate the fact that it is possible that President Bashir can enjoy immunity. But all what they're saying is that that immunity, he does not enjoy it in terms of the June agreement. So now, what we need to look at is whether the June agreement, read together with the other legal instruments, grant that immunity. Our case is that it does. President Bashir has that immunity. Now, if we go to the relevant instruments, the applicant contended that the state respondents are relying on the notice issued by the minister on the 5th of June 2015. That is incorrect, because the notice cannot be read in isolation. The notice must be read together with the relevant domestic instruments or domestic legislation, and that has to be weighed together with international instruments and international obligations of the Republic of South Africa. So we're going to demonstrate to this court that there is no inconsistency whatsoever between the domestic law to which the South African government invoked and the international law or international obligations that the Republic has. If we start by looking at the notice itself, the notice on the first line refers to Section 5.3 of the Diplomatic Immunities and Privileges Act 2001, and that is the South African domestic law, which, in our respectful submission, is relevant and finds application. But if I were to read the last three lines of the minute of that notice of 5 June 2015, it says that for the purposes of granting the immunities and privileges as provided for in the agreement between the government of the Republic of South Africa and the Commission of the African Union as set out in the notice. So what has been referred to by the agreement is a very agreement which has been attached to the answering affidavit, which I'll come to later. But if we turn the page of that notice to the next page, then we have a schedule there. And the schedule says agreement between the Republic of South Africa and the Commission of the African Union on the material and technical organization of the meeting of the 30th ordinary session of the Permanent Representative Committee. Then it is Article 8, which is the most relevant for purposes of this case, privileges and immunities. Then paragraph 1 says the following: the government shall accord the members of the Commission and staff members, the delegates and other representatives of intergovernmental organizations attending the meetings of the privileges and immunities set forth in Section C and D, Articles 5 and 6 of the General Convention on the Privileges and Immunities of the OAU. As we understand the submissions made on behalf of the applicant is that this article on privileges and this Article 8 on privileges and immunities excludes heads of state because they are not mentioned specifically. We say that submission is incorrect because the clear reading of this article is to confer privileges and immunities to members of the Commission and the delegates and others. Unless if it is the contention of the applicant that heads of state, by virtue of being heads of state, are not delegates, and if they're not, then we must know who are they.
Mokale, can I just ask you something in this context?
Yes.
The statement said that if you read clause 1, it refers to members of the commission, staff members, delegates, and other representatives, and then the crux of it, the case as far as he was concerned, of intergovernmental organizations.
Yes.
And let me say, heads of state, members of the union.
No, but we have there, if we can read the first line, where it ends with commission and staff members, then it is a comma. From there it says, the delegates and other. So that is important. The delegates and other. So I see no reason why we should read the delegates to mean that it is the delegates of intergovernmental organization, because that's not what that paragraph is saying. It says the delegates and other. So our submission is that it's very clear from the reading of the paragraph that this is all encompassing, and I'll come to the point where we have to then scrutinize if the heads of state who are presently in the Republic are not enjoying immunity in terms of this, then they're enjoying immunity in terms of what? Because this is not an immunity for President Bashir. It is immunity to all those who have been invited to attend the African Union Summit. So we submit that that paragraph is quite clear, that it is all encompassing in respect of those who have been invited to attend the AU Summit. Then,
sorry to disturb you, but if I understood the argument from Ms. Goodman on this point, I think your question is in terms of what then do delegates and heads of state enjoy immunity?
that is precisely my
I
question.
think her argument was in terms of international customary law. And in respect of President al-Bashir in particular, that has been taken away. I think that's how I understood the argument. But you may wish to deal with it now or at some other point.
Let me deal with it now. As I understand the applicant's submission is that the international law obligations of member states are domesticated by being enacted into domestic law. So yes, they may enjoy immunity in terms of international law, but that international law becomes domesticated. And we say that when a member state invokes that immunity, it will invoke it in terms of the domestic law that it has ultimately ensured that it provides impetus to the international law that seek to protect heads of state when they are in another country. And I may refer, as I was going to do, to Section 5.3 of Diplomatic Immunities and Privileges Act, because this is a domestic law, not an international law. But it's a domestic law which, when you read it, it seeks to give effect to that protection which we are dealing with at the moment. We have attached the Diplomatic Immunities and Privileges Act as Annexure C. And if I turn to Section 5.3, which has been referred to in the notice, Then it says immunities and privileges of United Nations, specialized agencies, and other international organizations. Then section 5, subsection 3, then says any organization recognized by the minister for the purposes of this section, and any official of such organization enjoys such privileges and immunities and may be provided for in any agreement entered into with such organization or as may be conferred on them by virtue of section 7.2. So we know that an agreement indeed was concluded, and that's the agreement that we have referred to. Then if we have to read section 7.2, to which subsection 3 of section 5 referred to, on the next page, then it says, conferment of immunities and privileges. Any agreement whereby immunities and privileges are conferred to any person or organization in terms of this act must be published by notice in the Gazette. The minister may, in any particular case, if it is not expedient to enter into an agreement as contemplated in subsection 1, and if the conferment of immunities and privileges is in the interest of the Republic, confer such immunities and privileges on a person or organization as may be specified by notice in the Gazette.
Is it any significant that section 4.1 in particular, which deals with heads of states immunity, is not mentioned in the agreement, in the notice, in the cabinet decision?
It is not significant at all, because then, as I've already pointed out, the agreement must be read together with the relevant instruments which I'm referring to.
Okay.
And of course, if I can then go back, to go to section 4, which I was going to refer to immediately after, then immunities and privileges of heads of state, special envoy, and certain representatives. A head of state is immune from the criminal and civil jurisdiction of the courts of the Republic and enjoys such privileges as, and then it sets out those then conditions in paragraphs A, then 2C. So this goes again then to the same point that I've raised, that an agreement was concluded, and that agreement in our submission is all-encompassing of all delegates, including heads of state, and in the absence of it, then one is unable to point out what protects the heads of state and grant them that immunity in terms of domestic law. So our respectful submission is that indeed South Africa has an obligation to observe international law and to take serious of its international obligations. In doing so, it must ensure that international law to which it has become signatory to in terms of conventions are domesticated, and once domesticated, then must be applied. So now we look at our Constitution, which also recognizes South Africa's obligation to observe and comply with international obligations. Our learned friend for the applicant has submitted, I'm not sure whether it was in the alternative, to suggest that if the agreement has not been promulgated, therefore, then it has not been domesticated and no rights can be derived from it. But if I may look at section 213, section 231 of the Constitution, section 231 of the Constitution, in particular subsection 4, it is chapter 14 dealing with general provisions, and it says international law, and it says international agreements. I'll submit that an agreement concluded under the auspices of the AU is an agreement that falls into that category because it is interstate in respect of a continental body. But subsection 4 reads as follows. Any international agreement becomes law in the Republic when it is enacted into law by national legislation, but a self-executing provision of an agreement that has been approved by Parliament is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. The Republic is bound by international agreements which were binding on the Republic when this Constitution took effect. In Section 232, which deals with customary international law, which our learned friend for the applicant has referred to, that it is the only one which will grant immunity to President Bashir, says that customary international law is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. In fact, we do not even want to argue.
Mr. Mukari, the agreement that was entered into, you submit that it was approved by Parliament.
That is the agreement that we are referring to here.
Yes.
Now, if we can go to the agreement, which is Annexure A. So this is an agreement between the Republic. Just a moment. So if we look at the agreement Annexure A, then it says agreement between the Republic of South Africa and the Commission of the African Union. So this is an agreement between the Republic and the Union. It sets out the terms of that agreement. Then what then happens to make it have a force of law? It must then be promulgated, and that promulgation has happened in terms of the notice that I've referred to as Annexure D of 5 June 2015, which refers to Section 5.3 of the Diplomatic Immunities and Privileges Act. So it did not go through the parliamentary process, but it went through the promulgation process. Because when I read Section 231, is that it must then be enacted into domestic law by one of the two, either through promulgation or through parliamentary process. So this one then has gone through the promulgatory process, thus giving it that force of law. And when one reads it, especially then Article 8, which then deals with privileges and immunities, it makes it patently clear that all delegates, and I say including heads of state, which will include also then al-Bashir, have been granted immunity. If I may then deal quickly with the submission that was made regarding the cabinet decision. Of course, that has been dealt with in the affidavit of Dr. Lubisi. The submission, as I understand, is that the cabinet decision which was taken in respect of ensuring that President al-Bashir attends the AU summit will not have a force of law because it cannot trump, just like the notice, international law. We say that this matter, looking at the decision of cabinet itself and the notice, does not even give rise to that argument. The argument does not arise because there's not been anything to suggest that there is any conflict between South Africa's international obligation and international law. So we say that the cabinet decision is well in consonant with the notice, the Diplomatic Immunities Act, and so it does not detract from the legislative instrument which give rise to that privilege. So our submission is that we see no conflict at all, and therefore the question of whether one trumps the other does not arise.
Advocate Mkhari, you'll pardon me here. I just want you to go back to the previous argument you made about either going through a parliamentary process or going through the promulgation process.
Yes.
Yeah, could you just deal with that again, because I'm not sure I understand what you're submitting to us.
Let me read
Is it
this.
in terms of the Constitution?
Yes, that's section 231,
Okay.
subsection 4 of the Constitution,
Right.
which says that any international agreement becomes law in the Republic when it is enacted into law by national legislation, but a self-executing provision of an agreement that has been approved by Parliament is law in the Republic unless it is inconsistent with the Constitution of an Act of Parliament. So Deputy Judge President's question was to the effect that does this agreement, or was this agreement tabled in Parliament consistent with the latter part of section 231(4). And my submission was that, well, it contemplates two processes in respect of international agreements, that either it is enacted into law, into a legislation, or then it is a parliamentary process because the agreement itself is self-executing. So I submitted that it is the former which is applicable, taking into account that this agreement was then promulgated in terms of this notice and to become law in terms of section 5.3, as it has been referred to in the notice itself. So it satisfies, in our submission, the requirement of the former part of section 231 of the Constitution, and that it actually answers the submission that was made by the applicants that it does not enjoy a force of law. So I would like to deal with a few submissions which I have picked up from the applicants' heads of argument, just to correct some of the submissions made.
Is it possible for you to deal with your section 4.2 argument, which is raised squarely in the answer by the Director General?
Section 4.2 of the argument says a special envoy or representative from another state, government or organization is immune from the criminal and civil jurisdiction of the courts of the Republic and enjoys such privileges as, and it sets out those privileges. So we have dealt with that in paragraph.
It's paragraph 3.18.1. I think the argument there is
It's
that
paragraph 3.18.1,
18.1.
yes.
And further, it's to the effect that that provision deals with criminal responsibility as opposed to immunity.
Yes. And we take it further in the same paragraph. We say, by providing that the fact that a person inter alia is or was a head of state or a member of a security service or armed force is not a defense to a crime as defined in the ICC Implementation Act. So the provision, then if you go back to it, it says a head of state is immune from the criminal and civil jurisdiction of the courts of the Republic and enjoys such privileges as And then from there, then a special envoy or representative from another state, government or organization is immune from the criminal and civil jurisdiction of the courts of the Republic and enjoys such privileges as. So your Lordship wanted me to clarify which aspect of that?
Well, I think I understand that argument to say, as you say, or as the Director General says, the argument based on Section 4.2 by the applicants is misconceived because it has nothing to do with immunity.
Yes, indeed.
That's the argument.
That's the argument.
You persist with that argument?
Yes, indeed. We persist with that argument. Hey, just a moment. Well, I mean, as my learned junior points out, that I mean, that would be an argument for the accused person, and then, so it will not find application for the purposes of the obligation of the state, as contemplated in this application. But before I deal with the heads of argument, there is one other point which I wanted to deal with. It has been raised with my learned friend for the applicant by Justice Fabricius. And as I understood the question well, it related to the implications of the pre-trial notice of the ICC that we find is attached to the supplementary affidavit of the applicant, and I would like to deal with it so that it can be understood in its proper context. That is KR case 16. As we can see on the face of that document, it's a 6-page document. At the bottom is one of 6. It says, Urgent Public, decision following the prosecutor's request for an order further clarifying that the Republic of South Africa is under the obligation to immediately arrest and surrender Omar al-Bashir. So when one looks at this opinion, which is not a judgment, it's an opinion, of the justice concerned, the name of the justice concerned appears on the 6th page at the bottom, and it is dated the 13th of June 2015, is that insofar as South Africa sought clarity on its international obligations, there is nothing to clarify because then the previous rulings are very clear as to what South Africa's obligations are in respect of al-Bashir. To the extent that it is sought to be submitted to this court that this detracts from the South African position in respect of its international obligation as domesticated by the Privileges and Immunities Act, we say that that is not what this opinion seeks to achieve. All what it says, it simply reminds South Africa that we remind you of your international obligation, that if he comes, then you have a duty to arrest him. But that is simply an opinion which came as a result of the South African government seeking its own advice, seeking the court's advice. But our submission is that when one looks at what the South African government then did to ensure that all heads of states are protected and granted immunity, there is nothing which detracts from what has been said in the opinion of the court. So we say that we do not see anything to suggest that this court will ultimately as a result of this opinion, say that South Africa has been ordered by the court to arrest al-Bashir. That is the reason why the applicants had to come to court for that issue to be ventilated by the domestic court.
Mr. Makari, just have a look at the first paragraph of the presiding judge.
Yes.
He says that he issues this urgent proceeding following the prosecutor's urgent request for an order clarifying that the Republic is under an obligation to arrest. Having regard to the procedure there, it's not merely an opinion that a judge in the International Criminal Court takes out of the blue.
Yes, it's true.
An urgent request was made to him by the prosecution, and if you see who was present, it was the office of the prosecutor, counsel for the defense, legal representatives of the victims, legal representatives of the applicants, unrepresented victims, office for public counsel for victims, and state representative.
Yes.
So it seems to go further than simply classifying it as an unwarranted or unwelcome opinion.
It's not an unwarranted opinion. All what I'm submitting is that it was an opinion of the court where it was asked by the South African officials to clarify its earlier rulings, and it said that there is nothing to clarify because South Africa is reminded of its international obligation in respect of the matter concerning al-Bashir. So it did not issue any new ruling different to that which was known all the years from the time when the warrant of arrest was issued against President al-Bashir in 2009. So it's nothing new to what was already in the public domain. So that is all what I'm submitting. So those will be if there are no questions then from the bench, I will submit that the applicants have failed to satisfy the first threshold, that is that President al-Bashir does not enjoy immunity in terms of the domestic legal instruments that South Africa has actually invoked. We say that to the extent that it is the applicant's contention that the domestic instrument conflict with international ones, then the applicants know what to do. That the domestic instruments, so far as they conflict with that, they ought to have made out a case for that, and that is not the case that they're advancing, or they ought to have taken the necessary steps to make sure that those provisions of the domestic instruments which conflict and make it impossible for South Africa then to comply with its international obligations are set aside. Only as at the end, or as a fallback position, the applicant was now saying that, well, we'll want to set aside the notice. And we say that that is not the case that we're called to meet, and if we're called to meet it some other day, we will do so. But for present purposes, the applicant has made out no case, and the application should be dismissed, and the interim order should then lapse to allow President al-Bashir to travel back to his country. Those are sufficient.
Advocate Mkari, just before you sit down, I think you'll have to talk to us about costs. But before you get there, I would also want you to talk to us about urgency, because this is raised in the papers. But the first point that I want to clarify with you, having listened to all the submissions, is it is not denied on your part that South Africa has international obligations in terms of the Rome Statute.
Yes.
And insofar as those obligations go, arising from the warrants issued against President al-Bashir, South Africa is excused from complying with those obligations in this instance because of the notice it has issued, because based on the domestic legislation that's here and the cabinet decision.
That's right.
So if he were to come here for a holiday, South Africa would arrest him.
South Africa will arrest him. That is why the applicants started their founding affidavit by making the court aware of the invitation that was extended to President Bashir in 2009 during the inauguration of the President of the Republic of South Africa. Because at that time, he was coming, or he would have come to the Republic as the guest of the government of the Republic of South Africa. South Africa could not assure him safety, and he elected not to come. But this is an entirely different scenario where an agreement was concluded between the South African government and the AU in respect of the AU summit, which South Africa has been requested to host. And that is the context in which it makes this matter different from the others that the applicant may wish to rely on.
Do you still persist that this matter is not urgent?
No. Probably then our learned friends for the applicant have not properly understood our submission in the answering affidavit. We're raising it in the context of, to the extent that, I mean, he has immunity, then there is nothing urgent. But we are not taking any issue with the fact that the matter requires to be dealt with urgently. In fact, then this full bench has listened to the arguments and it should deal with it as a matter of urgency.
And the issue of cost?
Well, we understand that the applicant as an NGO has the protection of the BioWatch Constitutional Court judgment, and I will not wish them to argue otherwise. So if the applicant is unsuccessful, then each party should pay its own costs. Those are submissions.
I was just conferring with my two brothers about the further proceedings. We are going to adjourn to consider the submissions made, but we'll request both sets of counsel to stay in court. We will communicate a message in the next 15 minutes when we will come back with the order today.
As the court pleases.
Before we go there, I think I know that Advocate Guman wants to exercise her right to reply. I do not want to be seen to be to be taking that away from her. I just wanted to make sure that Advocate Mukari hears this before he sits down.
My Lord, I'm indebted to your Lordship. I don't intend to be long. The main thing I wish to raise with you was to answer His Lordship Justice Fabricius's your Lordship's question about Security Council resolution. The Security Council resolution referred to in the decision of Justice Tartufo of the ICC.
Yes.
That Security Council resolution is the resolution that refers the situation in Darfur to the prosecutor of the International Criminal Court, and essentially starts the hands the matter over to the jurisdiction of the International Criminal Court for investigation and subsequent prosecutions. And in the same notice, it calls on member states to assist and support and cooperate with the ICC's efforts to protect human rights and the rule of law and to combat impunity in Darfur. And then it says, sorry, the computer is moving faster than I am, which happens to me all the time. In paragraph 6, it says that the Security Council decides that nationals, current and former officials, and personnel contributing from a contributing state outside Sudan, which is not a party, shall be subject to the exclusive jurisdiction of the contributing state for acts and admissions, unless such exclusive jurisdiction has been expressly waived. In other words, it says the Sudan conflict is, for the most part, under the jurisdiction of the ICC, except for people who are implicated in the conflict, who come from member states that have enacted the Rome Statute, and that, as I understand it, is giving effect to the ICC's jurisdiction as the court of last resort. In other words, it reserves primarily for the state court or the domestic courts to give effect to the Rome Statute if they can do so because they have enacted it, and otherwise it refers the whole thing to the ICC. So the effect of that Security Council resolution is to confer jurisdiction on the ICC. It's merely the first step in the ICC's process. It doesn't expressly deal with waiver, but by conferring jurisdiction on the ICC, we submit confirms that the Rome Statute is applicable over the Darfur conflict.
Can I just ask you that, is that why the word implicitly is used in the judgment of the International Court?
Correct, because it is not dealt with, but it must flow from the fact that the matter, by virtue of the Security Council resolution, is subject to the provisions of the Rome Statute. If I could, whilst I'm dealing with that, also deal with the status of the ICC's decision of the 13th of June. His Lordship Justice Fabricius has pointed out that on its terms it is a decision, and it was issued pursuant to a request from the prosecutor for an order as to the status of law. We submit that it's clearly not an opinion. Courts are not in the business of giving opinions. It's a binding decision, and it confirms an earlier ruling given in respect of the Democratic Republic of Congo. The principles of that decision are similarly applicable in respect of South Africa. So it's an extension of an existing legal principle to apply to a new member state or in different proceedings. It's in the nature of a judgment.
Just whilst on the Congolese decision, what wasn't clear in my mind was that also relating to an AU or an OAU organized meeting?
As I understand it, it was. I would need to check the facts on this, but my recollection when I was reading up on it was that there was an AU, not a summit meeting, but a lower level meeting to be held in Congo, and it also related to President Bashir's attendance at that meeting.
And does one understand that decision to say the state party who is hosting that meeting, if that's what it was, is disempowered from granting immunity to him because of the warrants that have been issued against him?
Yes, as I understand the decision, it operates at two levels. It says in the first place, there is no immunity at international law. And so insofar as you rely on an international law obligation as a member state, there isn't one on which you can claim your immunity hat. And then it says, in addition, insofar as the provisions of the Rome Statute are binding on you as a member state, those provisions will mean that there is no immunity for a head of state under the Rome Statute. I don't want to detain the court long. I think Mr. Makari and my arguments are clear. I think the main position to emphasize from our point of view is that we start at opposite ends from one another, the applicant and the respondent. The applicant's position is that the binding law is South African domestic legislation, except to the extent that it has been enhanced by the adoption domestically of international law, or to the extent that customary international law applies. The Rome Statute has holus bolus incorporated the ICC Act has holus bolus incorporated the Rome Statute regime, and so that is domestic law. The same is not true of domestic immunities, of immunities and privileges. Immunities and privileges apply in South African law only insofar as they're provided for under the Act, the Act provides that unless it is an immunity conferred by the 2 UN conventions or the 2 Vienna conventions, that it is done on an ad hoc basis, and that where a decision is taken to recognize, that decision is taken on the basis of the provisions of the Act, and it must then be given effect to by the publication of the notice. In other words, when the state is engaged in granting immunity under the provisions of the Immunity Act, it's engaged in ordinary administrative action. It must source the power in the Immunity Act. It must take a decision to confer the immunity on a particular individual, and it must then publish its decision in order for it to be effective. And once that is so, the ordinary principles of legality apply. It means the court is enjoined to ask who has the power to grant the immunity, and we say it is only the minister, and that's why the cabinet decision is out. And what is the legal basis on which she can do so? And there we say she can only grant immunity where she does so in accordance with existing South African law, and that means in existence with South Africa's obligations under the Rome Statute. It means in effect that she cannot ever grant immunity where the effect of it is to circumvent South Africa's obligations in terms of the Rome Statute, which is exactly what, on my learned friend's argument, the notice purports to do. That said, we do stand by our primary argument, which is that the notice deals only with the organisation of the African Union. We say that the use of the word other shows that those 3 categories of people are all categories of people working in the intergovernmental organisation. And to the extent that heads of state and other delegates seek to claim immunity, they must source their claim in the provisions of the Immunities Act. Heads of state can do so in terms of Section 4. UN members can do so in terms of Section 2. Diplomats and consulates can do so in terms of Section 2, but there is no basis we submit in terms of which President al-Bashir can do so. The only issue outstanding, then, we say, is the question of Section 4.2. We say that, again, the prevailing provision is Article 27, which makes clear that heads of state are not immune from proceedings against them by virtue of their positions as heads of state, and that is then given effect to by the provisions of Section 4 in its entirety. On a conspectus of all of those facts, we say there is no basis at all in South African domestic law for President Bashir to be granted privileges and immunities whilst he is in the country, and the provisions of the Rome Statute apply, and he must accordingly be arrested and surrendered.
In effect, what you're saying is, because South Africa is a state party to the Rome Statute, and there are these warrants, it is completely powerless to try and protect a head of state who's under warrant. That's what you say?
Exactly, my lord.
Okay. Anything else?
Unless your lordships have any questions for me, those are our submissions.
Advocate Mkari, we didn't ask you about the Congolese decision. I don't know whether you have any submissions you make, which is referred to by the 13th June decision or opinion, as you may have it, from the ICC pre-trial chamber.
Yeah. Well, what I know is that it was not an AU summit in the sense of the AU summit that we have here. So the context of what it was, I don't know, but it was not in the AU summit, yes.
And as we adjourn, I take it, having heard nothing from you, the status quo remains.
Indeed, my lord.
Thank you. We will send word back shortly. that the conduct of the respondents, to the extent that they have failed to take steps to arrest and or detain the President of the Republic of Sudan, Omar Hassan Ahmad al-Bashir, President Bashir, is inconsistent with the Constitution of the Republic of South Africa 1996 and invalid. Respondents are forthwith compelled to take all reasonable steps to prepare to arrest President Bashir without a warrant in terms of Section 40, subsection 1K of the Criminal Procedure Act 51 of 1977 and detain him pending a formal request for his surrender from the International Criminal Court. 3. That the applicant is entitled to the cost of the application on a pro bono basis. This is the order of the court.
I agree.
I agree.
Advocate Mkaro, you wanted to tell us something?
Yes, indeed, my Lord. The question that the court was asking me throughout as to whether President al-Bashir is still in the country has now been answered to me by the government during the short adjournment. I have been informed by the government that they have reliable information that President al-Bashir has departed from the Republic on his way to the Sudan. So the Minister of State Security and the Minister in the Presidency have informed me that the circumstances of his departure will be fully investigated. So that's all what I wanted to place before court.
Thank you, Advocate Mukari. We've handed down our order. Is there anything you want to say, Advocate Goodman?
My Lord, I accept that your Lordships have handed down your order. We submit that you are still seized with the matter, and we seek an affidavit from the relevant respondents placing on record when President Bashir left, who stamped him out, which port of entry he left from.
Yeah.
We submit that it falls within the jurisdiction of this court as a structural interdict, given what appears to be prima facie a violation of the terms of the interim order granted yesterday.
Thank you very much. I was just consulting as it's a full court. I don't take my own decisions. That's why I talk to my brothers. Advocate Mkari, is there anything you want to say to what Advocate Goodman is saying?
Yes, indeed. If the applicant would like to pursue any further avenues pertaining to this matter, then they know what to do. Then they will serve us with proper papers so that we can be able to respond. If they intend to bring contempt proceedings, then they will do so so that we can be able to respond. But what we're placing on record is that the Minister of State Security and the Minister from the Presidency have informed me that the circumstances of his departure and how he did so will be fully investigated.
Thank you very much. Thank you, Advocate Mkari, for that explanation. I think having had this disclosure at this stage of the proceedings, it has been clear to everyone since we started that we were, as a court, concerned whether we remain with jurisdiction or not. It is of concern to us that an order of this court that was issued and that was clear, that was to ensure the presence of President Bashir in this country until the finalization of these proceedings, has not been complied with, one way or the other. We would, as a court, request an affidavit to be filed, because we still have said we will file reasons in a week's time. We issue an order that an affidavit be filed with the registrar of this court within 7 days, disclosing the time when he left, the port of entry or exit that he used to leave. And then, as you say, Advocate Mkara, it will be up to the applicants to see to it what they do further. But it is of concern to this court that it issues orders and then things just happen in violation of those orders. So, be that as it may, that's the order we will issue under the circumstances.
That will be complied with,
My Lord, I do realise that I'm now pushing my luck, but in terms of yesterday's order, we were entitled to service of the bundle of documents that Mr. Makari had in his hand this morning, showing who at each port of exit was responsible for receipt of the order. Well, can we obtain a copy of that?
We'll make you a copy.
Thank you.
Thank you very much. Court adjourns.
Okay, but it looks like, unfortunately,
Break my heart a little bit with him.
so you wanted the president.
I totally wanted the president. What have we all been doing?
Thank you very much.